Guys, is that a plane? Is that a bird? No, it's Diddy's attorneys, and they have a brand new emergency petition, and their claims are completely outrageous. Hi everyone, this is Roby. Regular and daily content. Guys, pay close attention to this video. I have a ton of footage from today. Despite my headache, Diddy's attorneys are now requesting that I appear with this urgent file. This cannot be disregarded. Therefore, if you view the docket on KET.com, you can see that Diddy's attorneys are actually debating what constitutes prostitution and the fact that it has changed, so Diddy is not covered by it. The government's First Amendment arguments are unfounded, as they did not demonstrate that Diddy conveyed with anyone with the intention of engaging. They are at the very least claiming that Diddy was actually making amateur porn and asking for a new trial, which is necessary because of the bias in the evidence. When it comes to Diddy, the man's actions are unjustified because they burden protected First Amendment activities. In the interest of justice, the court may decide to mandate a fresh trial. It is impossible to deny an allegation of spillover prejudice. Therefore, a new experiment is necessary in accordance with the binding test. That is essentially the table of contents, or index, of the material we are going to read. I would like you to paraphrase that. Diddy is now requesting a new trial with 110%. Prior to Diddy's attorneys bringing it up here and in interviews, it was discussed. Diddy, who is now formally involved in litigation in this latest emergency petition, is requesting that a new trial be held because of bias that the prosecution side has brought about from the evidence. A new trial must be justified as a result. It cannot be turned down. Thus, he is using pretty severe language here. I'm really interested in hearing Judge Arun's thoughts on this new trial. Guys, Arun likes to get his lick back, and you know that Diddy's lawyers are putting a lot of pressure on him, whether he will acknowledge it or not. Consequently, I am eager to hear what Arun has to say. Now gentlemen, just pay attention to this if we read the introduction. Established that Sean Combs was a trafficker who operated a violent racketeering business. The prosecution spent 2 months. It didn't work. The jury dismissed its story. It was discovered that Diddy was not a racketeer, and that without the unsuccessful charges, the remaining Mon Act charges would not have been brought and should never have been. Under the legislation, no other individual in a comparable situation has ever been charged with planning, interstate travel, and providing money to adult men who engaged in consenting sexual relations with their adult girlfriends. Diddy's motion proved that the word prostitution cannot be interpreted as a constitutional prohibition on this behavior. Although it would be a reversible error, the administration believes the court will sidestep these problems. Such concerns of statute interpretation must be taken into account under Rule 29. According to established Second Circuit and Supreme Court precedents, the government's merits arguments also contradict the trial record and governing law in a number of respects. Due process federalism, the government misconstruing the rule, and First Amendment case law. As you can see, folks, if you read the entire argument and then scroll to the end, where it reads conclusion, you'll notice that it resembles the introduction a lot. It has a lot of juice. It provides a summary. Although it's only one line, it's really enjoyable to read. Additionally, that one line states that PDD merits a quibble or another trial. Judge Arun will not grant an acquittal. Therefore, if Judge Arun agrees, a fresh trial will take place. However, as you can see, Combs' arguments are appropriately presented to the court in this instance. Additionally, it's a lengthy 30-page document. Read a little of this, please. Over time, the definition of prostitution has evolved. The term prostitute has never had a set definition, as Diddy's gestures clarified. Late 19th and early 20th centuries. Nobody has the time to discuss the White Slave Traffic Act in the 19th and 20th centuries. Nobody has the time for this. You wanted to bring this bullshit to the table, which is why one of your lawyers left you. The table didn't topple over because no one gave a damn. Why are you bringing up definitions and historical occurrences related to the term prostitute in an attempt to help your client escape this insanity? For me, it isn't working. I'm so sorry. I don't even judge ARO people, and I don't believe this bullshit. Judge ARO isn't buying this bullshit if I'm not buying it either. He continues by discussing the definition of a prostitute, its historical development, how it has evolved, and the reality that there wasn't enough proof of closeness for finance. The government only cites proof that Ventura and Jane had romantic relationships with escorts after their trip, and that escorts were occasionally compensated. That does not, however, imply that Diddy or his girlfriends planned the freak hotel nights in order to indulge in prostitution. They are now claiming that there is insufficient proof to demonstrate that these phony workers were paid after traveling across state lines. Evidence on the events following the trip is the main source of information used by the government. However, the necessary particular intent must align with the fact that they are practically grabbing at straws in order to discuss what happened before and after an attempt to explain the precise procedures by which payment was made. Guys, it seems like you're attempting to make fun of the judge. As you might imagine, they keep saying that there is insufficient proof. Additionally, discuss Cassie's testimony, stating that she had no involvement and that there is just insufficient proof of Diddy's intentions. Based on a perverse pattern of freak-offs and hotel nights that occasionally entailed sex and occasionally resulted in payment. The government wanted the court to infer an intent to pay, but that was inadequate. Boom. Once more, the government disregards opposing evidence and exaggerates the evidence. The government argues that because Diddy performed at hotel nights and freak-offs, his actions were not protected by the First Amendment. The second point they are attempting to make is that the First Amendment principles apply in any situation because it was essentially amateur porn being made, which contradicts case law and the evidence. Lord, guys, please have mercy. Guys, I don't have time for this 30-page file. It is almost 1 in the morning. It's simply insane. Because of spillover, a new experiment is at the very least necessary. In the interest of justice, this court may decide to order a fresh trial. This is the section that interests me the most. Regardless of the basis of the petition for a new trial, the government contends that Rule 33 establishes an almost insurmountable barrier. This is not accurate. In fact, Rule 33 acknowledges that a trial court has broad authority to award a fresh trial if it determines, for any reason, that the trial resulted in a miscarriage. They are now claiming miscarriages of justice. And in justice, the government argues that a move for a new trial can only be granted in the most exceptional circumstances. But it bases this argument on instances in which the judge is unable to give a new trial without questioning the jury's integrity. Have mercy. Lord Diddy is not asking this court to consider the reliability of a witness in order to evaluate a claim, nor is he asserting that the convictions are against the weight of the evidence. He's making a retroactive misjoinder argument. This court has the authority to order a fresh trial on the grounds that it should be necessary if the interests of justice so demand. They then want to discuss racism and how the government was essentially in error. He explained in his motion to the district courts in both cases that subsequent mixed jury verdicts can result in rulings awarding fresh trials because of spillover prejudice. It's clear that they are now using more examples to support their claims. There have never been any cases just like this one. Even though new trials based on retroactive joiners following mixed judgments are uncommon, they continue to acknowledge that, given the mixed jury verdict, a fresh trial is unlikely. You should simply be pleased that you passed the binding test and were found not guilty by the jury. There should be a fresh trial. The government only partially addresses the three-part exam. It contends that since all of the same evidence would have been admissible, a new trial is not necessary. This is not a valid point of contention. In fact, it is wholly at odds with the manner in which the government presented its case to the jury. In summary, it contended that since the Mann Act only deals with transporting, the allegations against it were essentially distinct from the other offenses. In response, the government uses ambiguous and inconclusive wording, stating that since it is a murder act, some proof of violence would have been acceptable. They discussed the kidnapping of Mia or Capricorn Clark, as well as other related topics. There was no logical link between these perpetual episodes and any effort of the allegations under the Mann Act. This evidence wouldn't have even made it past the low relevance threshold. They are now discussing how most of these testimonials have nothing to do with the allegations of the Mann Act. Therefore, it is necessary to reverse these Mann Act charges. For them to be reversed, a new trial must take place. As a result, they are pressuring the men in this critical situation to file for the new trial since they are so desperate for it. Judge Arun must therefore answer this and provide them with a yes or no. They are essentially